Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to head all the way back out to the state of Illinois. As we know, they have a nasty assault weapon ban going on right there, and there's been a lot of litigation in multitudes of courts about this. Now, we recently did this video right here where we talked about how arrogant and evil the state of Illinois was, because on the matter of Calkins v. Pritzker, they had basically just told the Supreme Court, hey, I know you want briefing, but screw you, we're not going to give you any briefing. There's another case, though, one that the National Association for Gun Rights is spearheading. It's the case of Bevis v. City of Naperville, and we've talked to Rob Bevis, we've talked to Dudley Brown about that case. In that matter, Justice Coney Barrett had also ordered briefing on that one, and the state of Illinois has decided to file a response pleading. As a matter of fact, we've had a chance to geek out on it right here, and we're going to get through it today so that you can understand what the state of Illinois thinks of its citizens. So today, let's spend a few minutes, let's geek out on the brief, and let's talk about Illinois to the Supreme Court. Our citizens can just deal with it. Okay, the case we're talking about today, and we have talked about this case before, we've even talked to the named plaintiff on a couple of occasions, is Bevis v. City of Naperville. Now, this is a challenge to the City of Naperville's assault weapon ban, which is pretty similar to the one that we've been talking about in cases such as Calkins v. Pritzker, which is the Illinois statewide assault weapon ban. The big difference here is that the City of Naperville did not have a registration requirement like the state ban does. The state ban, as you know, if you want to keep one of those scary assault weapons, you need to register it by the end of the year. And we all know how well all of you are registering those firearms out in the state of Illinois. Now, this case was petitioned to a full en banc panel of the Seventh Circuit, as well as an emergency petition to the United States Supreme Court. Justice Coney Barrett sits on top of the Seventh Circuit. She supervises it. She ordered briefing. The state of Illinois was kind enough to reply, and I actually filed briefing on this case. We're going to go through just a few bullet points here, but essentially, I just want you to know, Illinois, what your Attorney General is arguing is, hey, there's nothing wrong with this law. It doesn't violate the Second Amendment. The arms at question here are not even protected by the Second Amendment. And candidly, all of our citizens in Illinois, you guys should just shut up and deal with it. And I should point out, what the plaintiffs are asking here is they are asking the United States Supreme Court to step in and impose an injunction on Naperville's law while the rest of this case percolates and finally comes to a final conclusion in the appellate court system. This is not an actual argument on the merits itself, rather this is an argument for an injunction. Now, one of the reasons that Bevis and the rest of the plaintiffs are asking for review is that there is a lot of inconsistent rulings throughout the nation as it relates to the legality or constitutionality of assault weapon bans. Now, according to the state of Illinois, however, that is not the case. It is a very universal ruling, and it is always to uphold the constitutionality of these laws, as they put in their brief. On the contrary, the Seventh Circuit is the only federal circuit court or state court of last resort to have addressed the validity of restrictions on assault weapons and large capacity ammunition feeding devices following New York Pistol and Rifle Association v. Bruin. And then listen, if you really want to know the disgust they have for Illinois citizens, just consider how they refer to Rob Bevis and his gun store law weapons here in attacking some of the other arguments made by plaintiffs' counsel. The Attorney General of the state of Illinois wrote in his memorandum, furthermore, applicants rely on a presumption of harm that this court has never applied outside of First Amendment cases, again demonstrating that their right to relief is not indisputably clear. Otherwise, they rely on inopposite Court of Appeals precedent and the alleged financial losses of a single gun store, neither of which shows that they will incur irreparable harm absent an injunction. Now, the big crux of the Attorney General's argument here is simply that the Second Amendment does not protect these sorts of firearms. What you say? I know, I said the same thing. As the AG put in his brief, as the court explained, the text of the Second Amendment is limited to only certain arms, and history and tradition demonstrate that particularly dangerous weapons are unprotected. And I, again, want to know the difference between a dangerous weapon and a particularly dangerous weapon, but I digress. So how can the Attorney General actually argue this with a straight face? We all know about the common use test. Yes, but you have to remember that there's a new and improved common use for self-defense test. I know there's no case that holds that. That's the creation of all of those who advance the cause of civilian disarmament. But the Illinois Attorney General flat out said, the court explained that both the Supreme Court decisions and historical sources indicate that the arms the Second Amendment is talking about are weapons in common use for self-defense and not machine guns, because they can be dedicated exclusively to military use. And yes, one of the positions that the state of Illinois is taking is there really is no difference between an M16 and an AR-15 other than the automatic fire function, and for that reason the firearm is exclusively for military use, cannot be used for self-defense, and therefore can be banned. The Second Amendment does not protect it. Ultimately, what the state of Illinois wants the Supreme Court to do here is absolutely nothing. They want them to leave it alone. They want this thing to ricochet around in the lower courts. They want to stall this thing out, which is a common tactic of those supporting civilian disarmament. Don't believe me? Take a look at Bianchi v. Frosch. That was GVR'd from the United States Supreme Court down to the state of Maryland in June of 2022. Here we are in December of 2023. No rulings yet. What about the Hawaii case that got GVR'd the same date, end of June 2022? No rulings yet. Now, one of the slight weaknesses to the plaintiff's argument is they don't have a pending appeal before the United States Supreme Court. They are asking for permission to argue before the United States Supreme Court. And the state of Illinois is using that to their advantage to say, hey, listen, you don't even know if you're going to accept review of this case, so why would you grant an injunction? As the AG put it, applicants have not shown, as they must, that the court is likely to grant certiorari to review the Seventh Circuit's decision. In fact, the court is unlikely to grant review because there is no circuit split on any questions presented. Further percolation is warranted and is occurring, and the court generally declines to review interlocutory appeals. Now, I agree in parts of that, but to suggest that there is not a circuit split is absolutely disingenuous. Now, one of the other arguments, of course, that the state of Illinois is making is, listen, when we're looking for historical analogs, we mean history at any time. So yeah, it might mean the late 1700s, yeah, it might mean the mid 1800s, but it might mean what just happened last week. Don't believe me. The cases that they cite as to why this law should be upheld as constitutional include cases from the following jurisdictions: Washington, Connecticut, Oregon, Connecticut again, Washington again, District of Columbia, Delaware, Rhode Island, and Oregon again. And they basically asked the court to delay this. This court, therefore, would benefit from further development of the party's evidence and the lower court's review of that evidence. In fact, the court usually denies review when a case is in an interlocutory posture, even when it presents a significant constitutional question. And then in addition to that, of course, the Attorney General needs to sprinkle on top like, hey, listen, they're not even going to prevail on the merits on this thing. This thing is absolutely frivolous. Of course, the law we passed is constitutional. As the AG put it, nor have applicants shown that it is indisputably clear that they will prevail under Bruin's two-step test. At the first step, applicants bear the burden of showing that assault weapons and LCMs are arms in common use today for self-defense. And again, we circle back to this in common use for self-defense, a theme that is replete throughout this memorandum, including here, as the Seventh Circuit explained, while the plain text of the amendment covers arms that ordinary people would keep at home for purposes of self-defense, it does not protect weapons that are exclusively or predominantly useful in military service. And then ultimately, the reason that the state of Illinois believes that this law should survive is because they know what's best for you. Obviously, the state of Illinois knows how you should be defending yourself. They put in the memorandum specifically, assault weapons and LCMs are not only unnecessary for personal self-defense, they may be counterproductive. Assault weapons are inherently dangerous in a home defense scenario because they pose a serious risk of overpenetration in most home construction materials. And of course, that would be dependent also on the caliber that that particular firearm utilized. Now, we all know that this is a common use test analysis. We've all read the common use test as announced in NAGR. We know what it means. But again, when the law is not on your side, you got to dilute or distort the law, which is exactly what the state of Illinois is doing here. When it comes to the common use test, they're basically arguing, hey, listen, the number of people who own them is irrelevant. It's the number of times these instruments are actually used in lawful self-defense, as they put it. But the Seventh Circuit explained the common use inquiry cannot be based on numbers alone or it would lead to an anomalous consequences as seen in the case of the AR-15. Think about that argument. If we rely just on numbers alone, like the test that says it should be, then you see, Judge, we lose. So because of that, we've got to come up with a new theory, which is how commonly are they used in self-defense? And then, of course, there's a high likelihood that the 24.4 million high-capacity magazines that were testified to at the lower court is actually an overinflated number. Now, I will point out that in Catano v. Massachusetts, we're talking about a couple 100,000 stun guns, and the Supreme Court found that no problem in being in common use. But here, the state of Illinois is willing to argue. But even if the common use standard relied solely on numbers, the record does not show that applicants are indisputably entitled to relief. They fail to address LCMs and rely exclusively on the claim that there are approximately 24.4 million assault weapons in circulation. However, they misattribute this number to Luis Claveris, an expert for the state in one of the consolidated cases. Claveris made clear that 24.4 million is a third-party estimate and likely to be an overestimate. Okay, so it's only 21.2 million. Does that mean that they're not in common use anymore? And then, of course, they have to do the whole, well, even if you do believe that the Second Amendment covers this, there is a rich historical tradition of allowing this to do this. I mean, take a look at and again, it's the usual suspects. The storage laws on gunpowder, the storage laws on primers, Bowie knives, the NFA in 1934, the same historical analogs that we see over and over and over in all of these state briefs. Now remember, the motion once again is to the United States Supreme Court to issue an injunction pending the outcome of this case. And I do agree with the state of Illinois that that would be an extremely rare remedy, one that you don't typically see out of the United States Supreme Court while a case is kicking around. However, it is very clear that Justice Coney Barrett has taken an interest to this. And let us remember that if this is on the emergency docket, it only takes 4 justices to approve it to have it reviewed by the United States Supreme Court. The case, once again, is Bevis versus City of Naperville. We'll link it all up down below so that you can geek out on the memorandum from the state of Illinois for yourself. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is right down there in the description box. Now, in the meantime, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.